Hi, everyone. Welcome to our unit on contracts. Contracts is a really big, huge, and obviously important topic in any class on business law. So we're actually going to spend 3 weeks just on contracts. And this first week is a pretty heavy one. So I want to ask for your patience this week as we move through some really important contracts topics. There's a lot of chapters to read in the book, but each one of them is pretty short. So I don't think it'll take all that much time. And what I'm going to try to do through this PowerPoint presentation, which I think should take me probably 3 videos to make, is to walk through some of those most important concepts with you. Again, my job here is not to repeat just everything that's in the book, but really highlight some of the key concepts. So the first thing I want you to do before we even begin is to pause the video. Maybe you've already read the chapters, but I want you to think for a minute, ask yourself what kind of contracts you might currently have or have had in the past. So pause the video and then come back. Okay, did you come up with some ideas of contracts? Perhaps you have a contract for your cell phone. I'm sure a lot of you thought about that one. Perhaps a lot of you are working now or certainly have worked in the past and you thought about an employment contract you might have. But what about the last time you stopped at Dunkin' Donuts and bought a cup of coffee? Was that a contract? Or if it wasn't a contract, then what was it? What we're going to focus on in this first week of contract law is exactly what is a contract and why is that so important in the law. And in doing that, we're going to talk about what makes a contract enforceable. So with that, I'm going to turn to a definition of a contract. A definition of a contract is a legally enforceable agreement. We make a lot of promises in our everyday lives. Haven't you ever promised, let's say, your mom that when you're out, you're going to stop at the store and pick up something for her, and then when you got home, you forgot? Or maybe you promised your friend you'd give him a ride somewhere, and then you just weren't able to, right? We make a lot of promises in our lives that we sometimes keep and sometimes don't keep. But when we talk about a contract, we're talking about a legally enforceable agreement. And what that means is if one of the parties to the contract, and we use this word party not to mean an actual get together and have a dance party, but the entities, the people, or the businesses that enter into this agreement are called the parties. And if you have a contract and one of the parties does not fulfill his obligations under the contract, then that entitles the other party to go to court and sue. For example, if you chose employment as your contract example, if you have a job where you work at a store selling clothes and maybe you're paid $15 an hour for selling the clothes at the store, what happens if your boss or your company doesn't pay you? Don't you have the right to go to court and force them to pay you for the work that you did? Of course you do. And that's what we mean by a legally enforceable promise, the right of one party to go to court and enforce that promise against another. Another example of something that's not a contract would maybe be a gift, receiving a birthday gift or giving a Christmas gift. These are not legally enforceable promises. You can't run to court and say, my best friend didn't give me a birthday present when he promised to do that for me, right? That's not a legally enforceable promise. The other thing I want to mention right at the beginning is where does our contract law come from? Remember way early on this semester, we talked about different sources of laws and we learned about the court system and we learned about the legislative branch and the differences between federal and state law. And we did talk about in our business entities unit how the source of most business entity law is state law. Well, the same is true of contract law. There is no national federal law of contracting. Contracting is a matter of state common law, meaning court cases have given us the majority of where our contracting law comes from. It's evolved over time through court cases. I will also introduce you to something called the Uniform Commercial Code, the UCC. We're going to focus most heavily on the UCC in our third unit, but that is a really important part of contracting law. The Uniform Commercial Code is not a national body of law like from the federal government, but it was evolved through a group of attorneys and practitioners who got together and said, in order for us to conduct business, we need some common contract law. We can't have contract law be so different from state to state because we need to transact business across state lines. So the Uniform Commercial Code only applies to commercial contracts, and we'll talk about those more in our last unit, but I want to make you aware of it now because it is an important source of understanding where our laws come from. And UCC laws differ a little bit from the common law because the goal of the UCC is to make transactions really happen. So we'll talk about that later, but I wanted to mention it now. All right, what I'm going to do I have a few more definitions to get through, and then we're going to talk about the contracts checklist. Okay, there is also a lot of terminology in contract law that a lot of these words you may have heard before, but it's really important to know the differences of what these words mean. In contracts, we have two types of contracts. We have bilateral contracts and unilateral contracts. You can certainly look in the chapter in your book to understand these definitions a little bit more. But a bilateral contract is what most of contracting is. It involves two parties making promises to each other. For example, take my cell phone. I promise to pay Verizon a boatload of money each month. And what does Verizon offer to do to me, for me? They offer to give me cell phone service. That's an example of a bilateral contract. Each party promises something in exchange to another. Let's say I promised to sell you my bicycle for $300. What did I promise to do? I promised to sell you my bicycle. What did you promise to do? You promised to give me $300. That's our bilateral contract. As I mentioned, most contracts are bilateral. We also have contracts that are unilateral. Unilateral means one party makes the promise and the other party accepts the contract by doing an action. Let me give you the classic example. Imagine, and let's hope this is not the case, I really do have a dog. Let's say my dog is lost one day and I offer a reward for someone who wants to find my dog. And I post signs all over the neighborhood. I post notes on social media. Please, if you find my dog, I'll give you $500. And if nobody finds my dog, I don't have to give anybody $500. But let's say you find my dog and you bring it to me. That is the action. By you bringing the dog to me, you have accepted the contract and I now owe you $500. That is an example of a unilateral contract. In contracting, we also talk about executory and executed contracts. This is actually really important. Go back to the example of the bilateral contract. Let's say today is Monday, you're listening to the video, and I call you and I say, hey, I'm just going to use the name Bob. And I say, Bob, I'm going to make an offer. Would you like to buy my bicycle for $500? And you say, yes, Professor Sherkerman, I want to buy your bicycle for $500. Let's meet on Friday to exchange the bike for the money. Have we entered into a contract? Is that an enforceable promise? Even though today's Monday, or do we have to wait until Friday? Can I go now and sell my bike to Steve instead? No. So we call that an executory contract. The parties have made the agreement, but they haven't completed the actions yet. That doesn't make it any less enforceable. Once we've made the exchange, let's say Friday afternoon, now we're talking about executed contracts. They've been done. The parties have done the actions that they each promised to do under the contract. Last but not least, we'll use some of these words throughout the videos. A valid contract, an unenforceable contract, voidable, and void. Void and voidable, you've probably heard these terms before. It means can't happen, can't do it, it's void. Sometimes in contracting law, when the contract doesn't work, the contract is voidable by one party, but not automatically void. Void means the law simply will just not recognize the contract at all. Versus voidable means one party has the right to void the contract. Okay, that was a long 10-minute introduction to this area, but it's really important to start thinking about this terminology as we move through our 3 units on contracts. Now we're going to get to the real bulk of what this unit is about. This unit now we call what makes the promise enforceable. Remember we said that in order to make a contract, which is a legally enforceable promise, we say that if one of the parties doesn't fulfill his obligations, like you don't show up and give me $500 for the bike, I have the right to go to court and sue you for it. The same way, if I stop paying Verizon for my phone, they're going to show up and serve me with papers and take me to court for not paying for my phone. If your employer doesn't pay you, same thing. But in order for the court to enforce that promise and say, hey, yeah, Sugarman, you are legally bound to pay Verizon for your phone, or hey, employer, you are legally bound to pay your employee. In order to get a court to say that, the court has to find that there is a contract between the parties. They can't just say, yeah, that sounds like it should be a contract. So courts have developed really what is a contracts checklist. These are the elements that have to be present in order for there to be a legally enforceable promise. I'm going to walk through each one of these, and that's what each one of these is a chapter in your book, walking through the contracts checklist. So we have offer and acceptance, something called consideration, which means something very different than it does in regular English. Legality, a contract has to be legal. There must be both capacity to contract and consent, and in some cases, the contract has to be in writing. That's actually one of my favorite topics in contract law, because a lot of us think a contract isn't valid or isn't enforceable until it's in writing, but that's not true. There's actually a lot of enforceable oral contracts, and I bet you have some yourself. All right, so let me begin right off the bat with the first contracts checklist matter, which is offer and acceptance. Okay, so in order for there to be a contract, think about your job example. If we have you and your employer, we need there to be one party to make an offer to the other. So your employer makes an offer to this potential employee that says, would you like to come work for me? You can work at Sugarman Bakery, and if I'm Sugarman Bakery, I offer to pay you $10, well, that's not minimum wage anymore in Massachusetts. Let's say $15 an hour to work at Sugarman Bakery. So when I make the offer to you, and then you accept the offer, and you begin to show up and go to work, we have offer and acceptance. What about the example of the car? I often like to use my own car as an example in addition to my bakery. I actually have a minivan. I tried to find a similar picture. Mine is blue, and it's a 2010 Toyota Sienna. Would anybody like to buy my 2010 Toyota Sienna? If you say yes, we might have offer and acceptance. But I wrote down here that the offer must have reasonably definite terms. In order for an offer to be legally binding, it can't be just this vague thing like, would you like to buy my car? If I say, would you like to buy my car, and you say yes, what have you agreed to do? Do you even know what kind of car I have? No. Do you know how much I'm asking for it? No. So in order for an offer to be legally binding, it must have these reasonably definite terms such that if somebody accepts the offer, we can really tell what it is. So if I say, would you like to buy my car? That's not a legally binding offer. But if I say, would you like to buy my 2010 Toyota Sienna with 175,000 miles on it for $2,000? Well, and you say yes, now we have a legally binding offer and we have acceptance. Some of the interesting things, though, that come up with offer and acceptance is how long is an offer open? Does it stay out there indefinitely? So if I'm making the offer, I can put a time limit. I can say, let me know by Friday. The other interesting thing about acceptance has to do with rejection of the offer. If a party rejects an offer, the offer is considered dead. There's been an offer, there's been a rejection, and now the offer is no longer on the table. Of course, the third option that could happen is a counteroffer. I can offer you my car for $2,000, and you can come back and say, how about $1,500? Now we've actually swapped. You have made the offer, and I have the party to accept, reject, or make another counteroffer. But not until there's been an offer and an acceptance has those two items been met. All right, I got through the first checklist item. I'm at the end of video number 1. See you on video number 2 as we continue the checklist.